All right, welcome to the property tax law change. This is the Prop 19 eroding Prop 13. We have disabled questions. We have a lot of people on this webinar. We have a lot of lawyers on the webinar, a lot of CPAs, a lot of clients, and a lot of friends of clients. So let's get right to it. This is a disclaimer. I'm presenting today with Conner Clemons from our law firm Cunningham Legal. This is not legal advice. This is information, and this is very important. The Board of Equalization has a document called an assessor's handbook. They have pulled that document off of the Board of Equalization's website. That's no longer available. That means there's a lot of change happening. The election results have not yet been certified. We anticipate that Prop 19 will be passing, but this is very, very important. The law is not fully baked on this one, so there are a lot of regulations that have to be created before we have definitive answers. This is our team of lawyers. We have offices in Northern and Southern California, and Conner's the third guy from the left there, and I'm the first guy from the left on the top slide deck. So Conner, you want to tell everyone what just happened?
Yeah, so over the past year, we've all been kind of watching Proposition 15, which was reassessing commercial property. A lot of money poured into that one, and it ended up not passing, about 48 to 52. 96% of the count has come in, and they projected that. But Proposition 19, this also affects Prop 13. This did pass, and it passed so narrowly, just a few 100,000 votes, which isn't a lot in California, that separated the pass from the no pass. And now here we are today. Now, this proposition, it wasn't put forward by the Board of Equalization. This was put forward really by a lobbying group, and we'll go more into that. So the Board of Equalization, they're trying to figure out what this law means just as much as attorneys are and clients are and everybody else.
Yeah, I was speaking with a personal friend who happens to work at the Board of Equalization. I live in Sacramento, by the way. I live in a place called East Sacramento. I live about 25 blocks from the Capitol. On a nice day, I'll ride my bike down to the Capitol. It's a beautiful garden. It's a great place to just kind of hang out. And so what happens is you meet people, right, who work for the Board of Equalization. Well, they're kind of scrambling. They're like, this is ridiculous. This thing is effective February 16th, which is 3 months from now. February 16th, they're going to have to rewrite a whole bunch of regulations, and they're not particularly happy about it. So to understand Prop 19, you have to understand Prop 13, okay? We pretty much all know what Prop 13 is if you're on this webinar. So what I've done here is I'm going to give you a visual of what Prop 13 is. So this is the 1970s. That's me as a little kid, and those are my parents. And so my mom and dad bought a condo in Ventura for $30,000. And when I was showing Conner this slide, he's like, "Are you kidding me? $30,000? Like, that's a car." But Conner, trust me, $30,000 was a lot more money in the 1970s. Okay,
those interest rates too, right?
Well, you're right, 20% or whatever they were. So my mom and dad buy this condo for $30,000, and a year later they move out. Okay, they move out, they rent it out. The property's now worth $435,000, and I will say this is very common. You know, California has high-priced property. California has low-priced property. Many of our clients in parts of the state, they might live in a house they paid $30,000 for that's worth $435,000, or have a condo like this. It's very important to understand. My parents are protected by Prop 13. And what this means is the assessed value of the property is not the market value of the property. The assessed value of the property is $71,000. Their tax bill is $834 a year. It's a very important property right. So what happens if they sell that condo? So if they sell that condo to this family, they move into the same condo, nothing's changed, but now the property is assessed at $435,000, and their taxes go to $5,000 a year. And so that's $834 versus $5,000 every year. And I've been telling this, if you've been watching our previous webinars, I've been saying the Republicans and the Democrats don't like Prop 13. People that run the state of California don't like Prop 13. 2/3 of the state's revenue comes from income taxes. And I've heard it's 35,000 taxpayers are paying the bulk of that income tax. So it's a very thin, wealthy strata of people that the state's dependent on for revenue. And that's not, regardless of political affiliation, that's not a good tax base. And so that's why California has this whipsaw where we'll have, in an economic decline, we might have a deficit, but in boom times we have a surplus, and that's just not, the whipsaw is not good. So the current property tax structure is weird in California. Okay, so property is assessed at 1% of market value when there's a change in ownership. A change in ownership is if, Conner, if I sell this property to you, or my parents give me the property, or I die and my kids inherit my property, all those events are changes in ownership. And a lot of people don't realize that death is a change in ownership. And frankly, a gift is a change in ownership. So after the property is assessed, so think of that example of $30,000. With Prop 13, the maximum the property taxes can go up is 2% a year, but real estate's been going up at more than 4% a year in many parts of California. And so that delta, that difference, so you've got the market value keeping going up and the tax base not keeping up with the increase in market value. And so basically long-term owners of California real estate have a very low property tax burden compared to more recent owners. And Conner, you and I have been talking about, Conner, you're looking at buying a piece of property, and taxes are a really big deal now. When I was Conner's age and bought my first house with my wife in Ventura, property taxes, they just weren't that much, but now it seems to be this really big part of a payment. Any comment on that, Conner?
I look at some of these houses, and property tax these days is a lot of normal people live in. So it's a big deal, and hopefully Prop 13 stays around for homeowners so that by the time I'm your age, Jim, my property tax will look really nice. But I mean, that's Prop 13 for you. Really, the longer you've owned property in California, the more favorable, I suppose, your property tax rates are generally.
And that's probably why you're here in the webinar. And for those of you who are lawyers or CPAs, you might be like, oh my gosh, when are you going to get to the good stuff? I really like to see how other lawyers talk about complex topics in ways where clients can understand about them. So for those of you who are professionals who are practicing in this area, I welcome to hear how you talk about this as well. So the current property tax structure, the black letter law is property is reassessed when there is a change in ownership unless an exemption applies. Okay, so there's two layers of definition. Is it a change in ownership between spouses? Typically not considered a change in ownership. And we'll talk about an LLC, right? A unique LLC. So there are two layers to this. Is there a change in ownership? And just because the property changes hands, this is very important. Just because the property changes hands, it's not always a change in ownership. But if there is a change in ownership, the property is reassessed unless an exemption applies. So parents can leave presently, right today, parents can leave a primary home of any value to their children and there's no reassessment. Now, Conner, what that means is, let's say we have someone who's watching here whose parents have a home in Pacific Heights that they bought in the 70s for $500,000. Might be worth $20 million today in San Francisco. That home can be transferred to the children, and the children inherit that low Prop 13 tax base. So instead of the property taxes being $250,000 a year, they're $5,000 a year. Okay, so that is a huge benefit. Now, does that happen in all cases? No, but it happens in large and small cases. So this is very important because Prop 19 does change this. So each taxpayer, each parent in this case, can leave $1 million of assessed value of property. And we're going to give an example of this. Assessed value, right. Assessed value. So we're going to give you an example of this, but Prop 19 is effective February 16, 2020. And look how this passed, 51 to 49. That is not a resounding majority in my mind. That's a very thin majority to amend the Constitution. But I think there are a lot of benefits to Prop 19. So do you want to talk about the good stuff on Prop 19, Conner?
So the whole reason why this thing passed was because it was really advertised, if you saw commercials, as a partial expansion of Prop 13, which is what it is. So Prop 19 allows you to you are over the age of 55, you have a home, you can now transfer your home even if the property is more expensive. So if you sell your residence and buy a replacement residence that's worth the same or less, no matter what the county is, you can take your property taxes with you anywhere. So if you live in LA County now, your house is worth $1 million. You can downsize, move to whatever county you like, and you'll pay the same in property tax, which is good, right? Now, if you buy a more expensive home, then you are going to pay the difference in market value between the old and new homes. So let's say you live in LA County, your house is worth $1 million, you bought it back in the day, so your property taxes are low. You go move to, I don't know, somewhere nice, Orange County, and your house costs $2 million. Well, you're going to keep that same property tax on the first $1 million of the property, but that new $1 million you will pay a new base rate at. Now, like I said, this applies to people over the age of 55. So over the age of 55, that's our first ambiguity in the law.
What is over the age of 55? As a lawyer, I would say it's the day after your 55th birthday.
But if you're a person, like if somebody asks you, are you over your current age? You're going to say, no, I'm my current age. It also applies to the severely disabled and victims of wildfires and other natural disasters. That's probably a cue that there wasn't probably enough thought when they chose the language for this new proposition.
So let's look at some examples. So, this is a really, this is an example that already exists under Prop 13. So it's something to understand. With Prop 13, if you're 55 or over, you can take your existing tax base and move it within the county, in all 58 counties, within the same county once in your life, and take your Prop 13 tax base with you if you buy a home of equal or lesser value. Okay. So in this case, they're moving between counties, and only a very few counties in California permit you to take your tax base from one county to another. But let's look at this example. So this is how Prop 19 benefits this husband and wife. So husband and wife buy a home in Pasadena, and you can see that Pasadena there, a home for $200,000. Today it's worth $1.2 million, and they pay property taxes of $5,000 a year. They're protected by Prop 13. They sell their Pasadena home to move up to Northern California to Roseville to be closer to their daughter. And that's the home they buy in Roseville. And they continue to pay the $5,000 per year in tax instead of, $14,000 a year. Right. So that Prop 13 is portable. So this is a really good benefit in my mind, in my view, of Prop 19 is now you can take your Prop 13 taxes to any county in California. So if you've been holding on to that house because of the low Prop 13 taxes, now we're not talking about capital gains taxes, because you can see there's a capital gains tax issue. You have $1 million gain. That's a separate issue. That's something that we help a lot of clients out with in terms of selling a home that's beyond a $500,000 gain. There are some strategies to mitigate that tax hit. Now, what if they upgrade? So you want to talk about this, Conner?
Yeah, sure. So this is a little bit more challenging, I suppose, to figure out how to calculate. But we have a very similar situation where you have the husband and wife, and they buy a home in Pasadena for $200,000 in 1980, just your run-of-the-mill home. And like many homes in Pasadena, it's worth $1.2 million today. And the husband and wife, they pay very favorable property tax for how valuable their house is worth, $5,000 a year. But they would like to move to Carlsbad. They've built their years making their money, and they want to move closer to the ocean. And they buy a house for $3.2 million. So now, if I were to buy this house in Carlsbad, or Jim, or any of you for the most part, you would pay $40,000 a year on a $3.2 million house. This is what I'm talking about. Like, you $40,000 divided by 12 months, that's more than a lot of people's mortgages or people's rent. But our clients here, they are able to lessen the load under Prop 19, because the first $1.2 million in this new home, it's going to be taxed at their old property tax base year value. So that $5,000 per year. The next $2 million is going to be taxed at $25,000. So their total tax on this new house is going to be $26,000 as opposed to the $40,000 if Prop 19 didn't exist. So it's really a taxpayer-friendly law when it comes to transferring property over the age of 55.
So who's behind Prop 19?
Who does it sound like? Who wants people to move?
Who do you think? Realtors, right? Imagine all the people who are going to move because they can take their Prop 13 tax base to any county, and they can actually buy something a little bit more expensive. So let's take a more earthly example. Let's say you sell the $1.2 million house and you buy a $1.4 million house in Roseville. Your property taxes are going to go up $2,200 or $2,500 a year. Not a big deal, right? But under current law, you'd be fully reassessed. So that's who's behind it. Now, Like, this is sort of the Faustian bargain. By the way, this was attempted. The realtors tried to pass this a couple years ago. It didn't pass because there wasn't a way to pay for it. Basically, here's how they're paying for it. So, the bad stuff, folks. Right now, that example I gave with my parents, where they bought the condo in Ventura, under current law, when my parents die and I inherit that property, I inherit their low Prop 13 taxes, even though it's a rental, even though they don't live in the property. I inherit their low Prop 13 taxes. That is eliminated effective February 16, 2021. This is a really big deal, not for you if you're the parent, but for your kids. It actually might be a big deal for you because many of our clients hold on to property knowing that this Prop 13 is a very valuable property right, and they want to pass this property right onto their children. That's going away February 16th. End of story. Done. Okay. So there's no parent-to-child reassessment exclusion. There is a very limited exception. And this is if the parent dies and occupies the home as their principal residence, and then the child moves into the home and occupies the home as the principal residence, you're not assessed on the base value plus $1 million. Everything above that, you're reassessed. We have some examples in here. But here's the bottom line. This increases the cost of keeping inherited property. Before we jump to our examples, I thought we disabled questions in here, so I'm going to go through these. We can get bogged down in questions, but I want to keep, these are relevant. Does the $1 million exemption, parent-to-child reassessment exemption, because we're talking about it, the Prop 13, does it apply in aggregate or to multiple properties? It applies in aggregate, and something you need to know is the Board of Equalization keeps a master index with your Social Security number on it. If you have filed a claim for reassessment exclusion, they keep, it's like Santa's list, right? The naughty and nice list. The Board of Equalization has your name and your Social Security number and the amount of the exemption that you claimed. So if you try and game the system, if you no one will find out, forget it. Dragnet or whatever, you know, we always get our man, the FBI. Everything sees the light of day. Do not do that. It's a really bad idea.
Let me tack on, Jim. Yeah. We were able to find out if people have burned through any of their $1 million exemption with the assessor's office.
That's right. Wish this could be repealed. I don't think voters understood it all. Yeah. You know, we have too many questions here. So we have
Jim too. I have like one of my contracts professors back in the day. He used to wear a shirt that said, "What the large print giveth, the small print taketh away."
All right. So here's the deal. Here's what you need to understand for lawyers out there. Okay. I was at an LA County Bar Association estate planning section yesterday by Zoom, and we were talking about the delays in recording a deed. Everything's backed up with COVID. If you submit a deed in January, that thing might not get recorded until March. Okay. So it's very important that you seek out expert help, and we're going to show you how to do that. But it's very important that you seek out expert help because everything's kind of in disarray right now. The Board of Equalization, they pulled off their assessor's manual, as I mentioned. The recorder's offices are backed up. It's kind of, the system is kind of starting to get gummed up, and you really do need an expert to figure out how to not step in it, quite frankly. All right, so this is effective February 16th, but the problem is February 15th is President's Day, February 15th, 2021. And so for lawyers out there, you get where I'm going with this. The real deadline's February 11th because the recorder's office is not open Saturday. It's not open Sunday. It's closed President's Day. And the Tuesday after President's Day is February 16th when the law becomes effective. So the real deadline is February 11th. Prop 19 guts Prop 13 for rentals. As I said, the parent-to-child reassessment exclusion is eliminated. This means residential, commercial, industrial, family vacation, and family cabins are not principal residences, okay? Everything's gonna get reassessed.
And let me tap on real quick.
Yeah.
I've had clients ask me already, if their child moves in to their vacation home or rental home within that 1 year after they pass away, are they protected? No, nope. They are not. You have to live there when you passed away for them to be able to move in.
So How do Prop 13 taxes work now when a parent dies and leaves a property to a child, at least until February 15th? Here's an example. This is a house I pulled off the internet. This is a house that's actually for sale in West LA. It's for sale for $1.7 million. This mom and dad buy the house in West LA in the 1970s for $100,000. It's now worth $1.7 million. It has an assessed value of $200,000. This is under current law. This is until February 15, 2021. If the child files a timely claim for reassessment exclusion between parent and child, because remember, death, right? Death is a triggering event. Death is a change in ownership where the child has to file this form, the claim for reassessment exclusion between parent and child. You got to give your social security number. Your name's going to appear on a roll at the state that there was a parent to child transfer. Okay. This is all the stuff that happens in the background that you don't really see as a consumer. Your taxes, if you're the kid, they stay $2,500. And most importantly on this, I want you to really get your head around this. They can only go up 2% a year. Let me say that again. Your Prop 13 taxes that you inherit from your parents can only go up 2% a year. So this is really, we have to kind of look at, if you're a child and you inherit this property, what's your remaining life expectancy? And what's the value of the difference in taxes you would have paid, right, if it was reassessed versus not? So this is Prop 13. Prop 19, this is after February 15, 2021. So mom and dad die after February 15, 2021. The home is a $100,000 home, now worth $1.7 million, assessed value $200,000. Now, the parents were living in the home. When the child inherits, the child has to move into that house in West LA. Well, what if the kid lives in Texas? They're like, my life is in Texas. My kids are in Texas. I don't want to move in that home. You don't get that property gets reassessed. So under current law, your kid can be living in Texas. Under current law, your kid can be living in Texas, take your $2,500 property taxes and turn around and rent that house out for $6,000 or $7,000 or $8,000 a month. Okay. And get the benefit of that. But with Prop 19, that won't work anymore. So the child has to move in the house. And here's how it's taxed. And this is very important. I'm going to slow down a little bit so you get this, because this is kind of the meat of a lot of the transactions we see when people pass away. Most of our clients own a home when they pass away. So here's what happens. The child inherits the home. The child gets the first $200,000 assessment that passes on to the child. The next $1 million is not reassessed. Everything over $1,200,000 is reassessed. And so what that means is you have your $200,000 assessment plus the difference between $1.2 million and $1.7 million, which is $500,000. So when you add those together, the new assessment is $700,000. I will tell you, and by the way, that $1 million is indexed for inflation. This is pretty complicated, isn't it? I mean, this is not something that normal people, when I say, this reminds me, my parents had some friends or have some friends. They had a doormat. It says a lawyer and a normal person live here. So normal people, non-lawyers would look at this and they'd be like, I don't understand this. This is crazy. So the bottom line, the bottom line is your property taxes go to $87.50 a year and increase $175 a year. Now, what happens if your parents, you're in Texas, kids in Texas, the parents aren't doing well, the child moves the parents to assisted living and rent the house out. Okay, so the house is a rental, $5,000, $6,000 a month. It's helping the parents in the assisted living. Because that's for them, it's probably, $10,000, $15,000, $20,000 a month. What happens? The whole property is reassessed. The property taxes jump to $21,000 a year. That's crazy. So here's what we look at. When we quantify, and this is one of the things that what we're doing this webinar, we're offering as a service. Go to our website, CunninghamLegal.com, sign up for an appointment. The appointment is going to last about an hour with you. There is prep time for us. We're charging $500 for that. Now, our firm traditionally has done no charge consultations for estate planning. This is totally different. So what we're asking is our clients sign up for this appointment by email. So go onto our website, say, I'd like an appointment. Somebody will call you back and get a time on the books. And we're going to need a few things that I'll go over: your tax bills, your current estate plan, and your basic assets and what you've gifted during your lifetime. We're going to go over that. But this is very important because this is the type of analysis that we're going to sit down and do with you guys, which is, hey, do you want to keep the house? Do your kids want to keep this house after you're gone? Because if they want to keep Prop 13 over a 25-year period, they're going to pay $80,000 in taxes. But with Prop 19, if it's a residence that passes to them, those taxes jump to $280,000. And if it's a straight rental under Prop 19, if it's not owner occupied and the child doesn't move into it, I guess it could be owner occupied and the child does not move into it, that's $680,000 in taxes. So we're recommending that our clients and people who are watching this, and frankly, the other professionals on here, the attorneys and the CPAs, you really need to reach out to your clients and have them engage in a discussion with you, because we don't have much time on this, okay? So we recommend that people act now to protect Prop 13 for your children if you want to protect it. This is especially true with the SALT deduction cap, the state and local deduction. Let's say this Prop 19 on the residence, those property taxes are capped right now at $10,000. So if the child moves into the property, the state income tax and the local income tax, there's a maximum federal deduction of $10,000. So hopefully that'll go away, but that's just another reason to be mindful of property taxes. Any thoughts, Conner?
No, I think you hit it right
All
on the
right.
head.
What about multifamily, commercial, and industrial properties? These are not residences. Now, someone will ask a question, well, what if mom lives in one of the units in the fourplex? Okay, well, that's more complicated. So let's just look at a rental reassessment. Lori buys, you want to do this one, Conner? Why don't you do this?
Sure. I mean, that's exactly it. Like when you say, what if mom lives in one of the fourplexes? There's no rules on that. The assessor's office figure it out, and they can write the rules, so we'll see. So Lori buys a fourplex for $100,000 in 1975, now worth $2 million, and she's paying $3,000 a year, $3,100 a year. And if there's a transfer after February 15th, the kids are going to get reassessed. And on a $2 million fourplex, they're going to pay $25,000 per year. So Prop 19 really hurts this family here. But if you act now before this change occurs, you can potentially pass on your low property tax base to your kids. And if you think your kids are going to hold on to this property, or maybe one of your kids holds on to this property, it might make sense to somehow transfer the property to the child.
But there are a lot of and I'm looking at the questions here. There's a lot of questions that we're going to cover. So let's see here. So let's break this down. This is before February 16th or after February 16th. And we're just talking about property taxes, okay? So we'll just table capital gains taxes. We're going to cover that in a minute. With Prop 13, if you get this to your kids now, over the next 25 years, the kids will pay $100,000 in taxes. If you transfer that property or die after February 16th, it's $841,000 in taxes. Now, I don't care if you're rich. I don't care how much money you have. That's a lot of money. We're talking a serious amount of money. We have many, many clients who bought multifamily homes in the urban markets, Bay Area, LA, even Sacramento, where the property values have gone up so much. If those get reassessed, the taxes are just kind of crazy. So we recommend that you book a consultation with us. We'll go over your situation. And the whole point of the consultation is to figure out, should I do something or not? Because if after the consultation we come in and you talk to the kids, maybe talk to the family, and they say, well, mom, we're going to sell that stuff anyway, then don't worry about it, right? If you're going to sell it anyway, it's better to sell it, and we'll see. It's better to sell it after, in many cases, after you pass away, because you get an adjusted cost basis. We'll talk about that, unless you have a taxable estate, which is a whole other issue, okay? Meaning if your assets are over 11.5 million. So what about, as I was preparing for this, I was thinking about rent control. Many cities in California have rent control. What happens if the property tax values go up so much that it basically consumes all the rent? What's going to happen? Is the property value going to decline? I don't know. How's this all going to work, right? So we don't really know. Kind of scary, frankly. So Planning strategies. So what do you do? Okay. What do you do before February 16, 2021? Can't you just give it? Okay. Can't you just give your property to your kids now? Conner, yes, right?
Yeah, sure.
And some people do. It's simple. Fewer legal fees. You still have to do your claim for reassessment exclusion. The cons are loss of control. The other thing is your low cost basis. So if you buy something for $1 and sell it for $3, your $1 is your cost basis, and you got to pay that tax on that $2 gain. When you give that $3 thing to your kids, they have to pay the capital gains taxes, right? So it may not be capital gains tax efficient. So if the kids say, well, yeah, mom, give this to me, but I'm going to sell it in 2 years. Well, you can do a 1031 exchange, all these other things. But again, this is why it's a good idea to meet with us, because we can go over the situation and flesh this out in a meeting and essentially figure out, it's really binary. The purpose of the meeting is to find out if there should be another meeting, right? Another planning meeting, something more for people who want to preserve their Prop 13 tax base. The other thing is asset protection. So half of marriages end in divorce. Your kids can get involved in lawsuits. Bankruptcy, the leading cause of bankruptcy is health. I mean, people get sick and they, can't work, can't pay their bills. Loss of rental income, that's another one. And frankly, your child may die before you do. So then, people, that's called dying out of order. So what's the verdict on this one? I would say it's unlikely to be appropriate in most situations. Probably some limited situations. We already have many people calling before this webinar even started. They booked appointments with us. They want to get in because they want to make sure, because they understand that a lot of people are going to be seeking out the services of expert lawyers like us. And we're not the only experts, right? But other expert lawyers as well. And we're just going to be busy. We may not have enough time. In some instances, it may be appropriate. In others, no, it just depends. So what are capital gains taxes? You want to talk about that, Conner?
Yeah. So we're not just worried about property tax. We're also really concerned about capital gains. That's another layer of tax here. It's just like when you sell any capital asset, whether it be a house or a stock. But for our purposes, we're going to talk about basis. That's going to be your purchase price plus improvements minus the depreciation. But we'll just stuck with the purchase price for now to keep it simple. Let's say you buy a house like we've been talking about for $200,000 back in the day, and now you sell it for $1 million. So you can see here, sale price $1 million minus your basis equals your taxable gain. So in my little hypothetical, that's an $800,000 gain, and that's going to be taxed. And tax rates all over the place. I think the lowest for most of our clients is 24.3% when you combine federal and state. And our high-end taxpayers, they're paying more like 35, 36% on their capital gains. So this is what we're talking about. We have to analyze all these different things before someone can make a determination about whether it makes sense to deed a property to a child or use a trust. Because at death, if it's inherited, property is generally, it gets an adjusted basis to fair market value at date of death.
Yeah, and the example is when Steve Jobs passed away, his wife had $450 million, I believe it was in Disney stock, with basically a zero basis. That should have been, if it was sold during lifetime, a $150 million capital gains tax bill because they were California residents. She was able to sell that stock and pay zero capital gains tax, saved $150 million in tax. This is a big, big benefit. The example of the home, I showed you the condo earlier with me and my parents in front of the old 70s Lincoln. That house that they paid $30,000 for, when one spouse dies, when either my mother or my father die, if it's community property, it gets an adjusted cost basis. So what happens is many times a spouse will pass away and you'll have the surviving spouse, that's the person who survived, the surviving spouse. That surviving spouse can then sell property and not pay capital gains tax, right? Because you get an adjusted cost basis as the date of death. So in this limited circumstance, I mean, I was thinking about this, getting ready, Conner, this morning for it, is you may have a mom who's 92, right? She's in an assisted living facility and she has that fourplex apartment building. An outright gift might make sense, right? Because now she's gotten an adjusted cost basis. If there are no creditor protection issues, divorce protection issues, it might make sense. And that might be the advice that we give the client. Yeah, make an outright gift. It might not be the advice. It just depends. And so the whole point of this is you need to talk to an expert to figure out what your next steps are and whether you should take those next steps. So let's look at this sale of the rental property. So you remember Lori's $100,000 fourplex she bought in 1975. It's now worth $2 million. If Lori sells it now, she's going to have a $2 million gain because it's $2 million minus her cost basis, or 1.893 million gain. The gain in the value is $1.8 million, but she's also depreciated it, right? She's also depreciated the property down. And so this is going to be taxed at her federal capital gains tax rate. On the recapture of depreciation, it's actually 42.1%. And then on the regular appreciation, it's taxed at 37.1%. Tax bill $734,000. Yikes, that's a lot of taxes. If she dies under current law, she gets an adjusted cost basis. The kids sell the home, zero gain. So the kids save $734,000 in taxes. Lori has to die, right? She's got to die for the kids to get this benefit. This is good for Lori's kids, not so good for Lori, okay? But it's good for the kids. And so before you just jump and say, oh, let's give the fourplex to the kids. Well, if Lori just says, I don't want to waste money with a lawyer. Lawyers do, I think I can do this cheap and simple, and I don't, I'm just going to do a deed. I'm going to do a quick deed. It's actually a quit claim deed, but I've heard people call it a quick deed. Those kids are going to have a $750,000 tax bill because you didn't get the right legal advice. So very important to get an expert. So should she give her kids the property? Well, maybe, but they take her basis. So if and when they sell the property, they're going to pay more taxes. And if they keep the property, they won't be able to depreciate the property. So basis is an important issue. So there has to be a better way than an outright gift. Okay, there has to be a better way. So internally, we are calling this a Proposition 13 trust. So it is a variety of trust and trusts with different attributes depending on whether people want an adjusted cost basis at death, because the deal is there's the good, like the you giveth and taketh away, the t-shirt you mentioned your professor said, to get a cost basis, that property is included in your estate for tax purposes. Well, the problem is estate taxes are 40% and they're due 9 months after death. Capital gains taxes are 37.1% and they're not due until you sell the property. When you give a property, no capital gains tax. There might be a gift tax. When you inherit property, that's not a sale. A sale is when you sell the property and get money in return. That's when you realize a capital gain. So this is why it's important to talk to an expert. Some clients may want to include the value of their property in their gross estate. And this is kind of a technical term for lawyers and CPAs and more sophisticated clients. But other clients may not want to include that in their gross estate because they may have a larger estate. So the idea with this trust is to preserve Prop 13 for your children. You have to deed the property. You have to set this up and deed the property well in advance of February 16th. But I think it's best to finish the plan after the Board of Equalization comes out with its regulations. Now, when is the election certified? Is it December 1st, Conner?
A little bit later, I think December 4th or 5th.
December 4th or 5th. So hopefully the Board of Equalization will come out with the appropriate regulations and we'll have those. But here's kind of the basic idea. We're going to be meeting with a lot of people this month and December, and we're going to have that initial meeting. Okay, what should you do? We're going to kind of rough out a plan. And then once the regulations come out, make sure that that plan is written in a way that doesn't kind of step in it and get you reassessed for Prop 13. So this is kind of a, come visit with us. We'll do some work and then we'll finish it up once the rules are solidified. But our goal is to have all of these done by January. So we don't want to be recording stuff in February. It's a bad idea. Conner.
The big thing with this Proposition 13 trust, why would you do this versus just deed? It really allows us to make decisions down the road, and it allows our client, the grantor, the parent, to retain some type of interest in this property, to provide asset protection to the child they're transferring to. Because if you just give your property to your daughter, If she goes through a divorce, that property is going to be mentioned. It's going to be part of her divorce. And these trusts, that's not necessarily the case.
Again, there's no one size fits all. Now, for those lawyers and CPAs out there, we're looking at grantor trusts. We're looking at non-grantor trusts. We're looking at trust protectors granting the grantor a general power of appointment at a certain period of time in the future. We're also looking at granting the grantor a general power of appointment to the extent that there's available exclusion amount in the estate, their basic exclusion amount, or whatever the future amount is. So those are some things that we're working through. These are very well established rules. Some of them are more well established than other rules, but they are highly case specific. They're highly client dependent, highly factual dependent. So people coming in with similar looking transactions might end up with different plans because of their particular situation. So we have some questions here. We got a lot of emailed questions. We have 30 questions in the queue. I'm happy to stick around and answer these, but we're going to get through some of these other questions that people asked. So this is really, I think this is the best question we got. Rick W. asks, I have several rental properties. Should I quit claim or transfer them to my children now? I'm 70. I bought my home in 1978 for $94,000. It's worth more than $2 million. How can I protect my Prop 13 taxes for my kids? You got probably 10 issues in there, Rick. Go to our website, book an appointment, pay us the $500, get us your property tax statements, get us your estate plan. We will also have you complete what we call a client questionnaire, which is who your kids are, your family are, and your basic assets, your general assets. Because we have some people with a $500,000 estate and we have some people with a $50 million estate. So we just get a wide variety of people coming in.
And not only that, but the kids too. Are the kids going to move out? Are the kids going to live there? Do they want to rent it out? There are so many different factors. We don't know where to begin.
Yeah. And part of this is having a meeting, and then you might have a homework assignment, right? Maybe over Thanksgiving, right? If you're meeting with your family, you can say, well, hey, if I die, do you guys want to keep this rental property or not? Now, what we find is many kids want to keep the rental property because, you can look at it as gaming the system, maybe, but they're able to keep that Prop 13 tax and they're able to get the economic benefit that would have otherwise been paid to the county. So the exclusion amount for 2020, this is called the basic exclusion amount, is $11.58 million, meaning you can give $11.58 million tax-free. By the way, it's a topic for another webinar. If you have a net worth of greater than 5 million, you might want to consider looking at gifting, because I call it the Biden exemption. Joe Biden's platform is to reduce the exemption to $3.5 million. What that means is an effective increase in death taxes. And that Biden exemption, if it goes down to $3.5 million, that means that estate taxes go up, because anything above $3.5 million would be taxed at the current rates of 40%. But something that's very important to understand, the highest tax rate we had, the highest death tax rate, was 77%. And that was in the early 70s. It is possible we could go back to 77% death tax rate. So it's very important, if you have any kind of assets at all, really take a hard look at maybe gifting something this year. Now they say there's no look back once the exemption is lowered, but the problem is if you give a $3.5 million gift and the Biden exemption is law, you have no exemption left. It comes off the bottom. It doesn't come off the top. That's the bottom. That's the bottom line. California may also impose their own death tax. That is on the table. That was a proposal. They're also proposing raising income taxes to 16.3%, which, when you look at the Prop 13 going away, you look at the income tax increase, you look at the death tax, you go, why do people, no wonder people are leaving California, right? But again, it's the great place to live. So when you make a gift greater than $15,000, you want to talk about what they have to do?
Yeah, so whether you make a gift via deed or through this Prop 13 trust, you are making a gift and you have to file a gift tax return with the IRS. And this is something that we do with our clients all the time, because the IRS wants to track how much money you've given away during your lifetime, how much you've deducted from your $11.58 million exemption. If you've given away more than that, they're just going to tax you then. but you have to report to the IRS what it is that you're doing. So even if you make that little gift of a house worth hundreds of thousands or $1 million, you have to report it.
And people say, well, what if I don't? It's like, well, if you don't report cash income, I mean, it's not lawful. It's a problem. And the government does track all your gift tax returns as well. Should you seek advice? Well, this is a really interesting question. Should you seek advice or not? And I would say if your kids, now there is a parent to grandchild reassessment exclusion that is used in very limited circumstances because the grandkids who inherit from the grandparents, both their parents have to be deceased. And that frankly, just doesn't happen too often. So if your kids plan on keeping any property as a rental or vacation home, even your residence, even your primary residence, then gifting strategies should be considered. I'm not saying to do it. And this is a very important distinction. I'm not saying go out, yeah, come in, do all this stuff with us. It's no, let's have a conversation and let's see if it's appropriate for you. And if it's not appropriate, we're going to tell you based upon what your plan is. I don't think it's appropriate for you to do any sort of, complex or big plan with a lawyer. It just may not be appropriate. But if your kids, and so if your kids are going to sell your property after you pass away, preserving Prop 13 and Prop 19, it just may not affect your family at all. But I think you're here, the people who are here because they want to pass those low Prop 13 taxes to their kids. So if that's you, I would encourage you to go to Cunningham Legal. If you just go to Cunningham Legal, there's a button to book your appointment. That's actually the link, Cunningham Legal. Seek out an expert. Conner, is this a do-it-yourself project?
No, it's not. And I mean, really, it's because of the advice. That's what you're looking for, not so much filling out a form.
Yeah. And I would say there are no, when we do estate planning and living trust, there are sort of common themes and common approaches to estate plans. And one, although they're different from each other, they kind of, one in many ways resembles the next. This is totally different. It's so highly dependent on so many factors. Do you have a taxable estate or not? Do you want an adjusted cost basis when you pass away or not? Do you, what if you give one property to one kid and not to the other kids? You might need to revisit your estate plan, right? Because if the one kid gets the house or the rental property, and then your estate plan says everything's divided equally when I die, well, that one kid's getting more. And that might not sit well with the family, to put it mildly. Are you in a position to give away your real estate or not? Are you financially secured? Do you have estate and death tax issues? So we're going to be sending out a follow-up email. So if you don't go to the website, we're going to be sending out a follow-up email where you can book a time to call. And by the way, if you're a lawyer or a CPA and you want to book an appointment and go over it, I'm fine with that, right? We're happy to do a training. If you want to pay us to, brainstorm or something, that's fine too. So you have to be really, really careful. So we typically advise against just deeding your property to your kids without an estate plan. Life estates won't work because when a life estate where the parent transfers to the kids the remainder and keeps the interest for life, when the parent dies, that's considered a change in ownership. So that won't work if the parent dies after February 16th. From the properties. What if your child passes away before you do? What if you change your mind or want to take the gift back? These are all issues that we're going to talk about. And there are planning structures, believe it or not, there are planning structures where you can do a lot of this, but we have to reconcile that. We have to reconcile that with the change in ownership rules with Prop 13. Pay attention to your estate plan. Again, you want to talk about this, Conner?
Yeah, of course. I mean, if you're going to deed, you have an estate plan, most likely. The estate plan should reflect that gift you make during your life. If you create the Prop 13 trust, that property is no longer yours, and you should make sure that it's consistent with your regular revocable trust. Because we have lots of clients who maybe gave away a house to two people in their estate plan, and now they want to deed it to one child because of this Prop 19. That can create an inconsistency that your kids, maybe there's no legal battle, but your kids will be disappointed once you pass away. Now, even if we decide that it makes sense for Proposition 19 purposes, Proposition 13 purposes to deed houses to a kid, you might recognize capital gains if you make that transaction with your child. So you can't just think about the property tax element. There's also the capital gain element as well.
What about a B trust? So if your spouse, what I'm talking about here is if your spouse, or if your parents, if one parent's passed away, or, it's a situation where they're two spouses, they create an AB trust. This is sort of an ancient structure. A lot of people have legacy B trusts. So this is where one spouse has died and there's an irrevocable trust created for the benefit of the surviving spouse. If your spouse has passed away and you're going to want to get on this pretty much like immediately, because it may take a court petition to terminate the B trust. But you may want to consider terminating the B trust and distributing that property to your children now to preserve Prop 13 taxes, because when the surviving spouse dies and that B trust property goes to the kids not only do not get another adjusted cost basis, which is a whole other issue, but then the property will be reassessed to the extent the property's in the B trust. Sometimes half goes in the B trust, half stays in the A trust for the surviving spouse. But a lot of times an entire property will end up in a B trust, and that will be reassessed unless you do something, now, unless you meet with us. So again, if you have a B trust, and I think, Conner, maybe we should rank these. If people call in and they say, oh, I have a B trust, we should probably meet with those people first. Because there's a lead time on going to court to terminate a B trust. By the way, on an irrevocable trust, when somebody's died, it's black letter law in California. You have to go to court to terminate the trust. I know lawyers listening to this say, well, we don't do that in this county or that county. I just look at the probate code, and we take a very conservative approach. This is something that's very important. Pigs get fat and hogs get slaughtered. Our firm takes a very conservative approach on everything we do. We don't want our clients to get in trouble. It's just not worth it. So what can you do after? Talk about this, Conner. What about going forward? What are the best practices? Let's talk about it.
What is the saying? An ounce of prevention is worth a pound of cure.
Yeah.
So what can you do now? Because Proposition 19 is going to end this parent-to-child exclusion. Is there going to be a way to transfer the low property tax base year value to your children in the future, even after Prop 19 goes into effect? And the answer is yes, but it's not really simple. It's something that requires a lot of planning. So it involves entities. So if you're going to buy a second home, like a rental home, or maybe you're going to buy a commercial property, you should consider purchasing that property in an entity like an LLC. Now, when I say purchase, I mean it never goes into your name as an individual. It goes into the LLC's names. Because when the LLC owner dies, reassessment can be avoided if the property was originally purchased by the LLC. So
let that one sink in, guys.
So we'll give an example here where you and your spouse purchase a home for $1 million and you rent it out, but you purchase the home in the LLC, not in your names as trustees or as husband and wife. You buy it in the LLC. Now the home is worth $3 million and you're still paying that low property tax. Well, when you pass away, you can pass a 1/3 interest in this LLC to each of your hypothetical 3 children. And because no child owns more than 50% of the LLC, there's no change of ownership. But for this to work, the properties must have been acquired by the LLC in the first place. They can't be acquired by you, the individual, and transferred to the LLC. Board of Equalization doesn't like that.
Yes, so this is really important. You can look at Prop 19 as destroying the parent-to-child reassessment exclusion. You can look at Prop 19 as enhancing Prop 13 for homeowners who are 55 and over or severely disabled or the victim of a natural disaster. And there's this exception's been around for a while, by the way, the LLC. So that's why when clients say, well, people keep telling me to buy a property with an LLC. Why? This is one really good reason.
That's
right?
even better now.
Because Prop 13 is still around, folks. So you buy this property and the assessed value only goes up 2% a year, but the market value is going up 4, 5, 6% a year. So over time, that Prop 13 benefit is an enhancement. And I will say that as one in my next door neighbor is a big commercial property guy. And he said, one of the benefits of Prop 13 is it is a stable property tax system. So in other states, they go, oh man, we have a budget shortfall. We're going to add more property tax on. When Prop 13 was passed, by the way, the average property tax rate was 2.67%. They cut that down to 1. Now, if you say, well, it's not 1, it's a little bit higher because each county can add on, like a school district bond or some, flood control or vector control or all these different sweeteners that go onto your, or bidders that go onto your tax bill. But the LLC, so going forward, if you think, gee, Prop 13, parent to child's going away, and I'm going to be buying property, it's a good idea to think about buying it in an LLC.
So another example too, and because I have a lot of clients that just want to leave their property to one kid or their property inside this LLC to one kid. So change of facts where you still have the spouse who purchased it for $1 million. The house is worth $3 million. They don't have 3 kids though. They just want to give it to their son. Well, they can structure it so the son ends up with 48% of the entity, daughter-in-law ends up with 48% of the entity, and grandkids own 4%. Nobody owns over 50%, so still no change of ownership. And we're really modeling this particular case here after the legendary case, the Michael Dell case that everyone's been talking about this week. I've had clients call in and say, I hear with LLCs, you can transfer and avoid the reassessment. But like we just said, if you own the property now and it's in your name, it's sadly too late. But going forward, when you buy more real estate, put these properties in an LLC.
Buy them with an LLC. Don't put them. And by the way, it won't work if you're like, well, I watched your webinar. I'm going to go out and create an LLC and put the property in it. Problem solved. Doesn't work that way. The LLC has to buy the property. Okay. By the way, if your son gets 51%, it's reassessed. The whole property is reassessed. So as long as there's no change in, as long as no one person gets more than 50% or there's no change in control, there is no change in ownership. And remember at the beginning, I said, we have to figure out, number one, if there's a change in ownership. And then number two, if there is a change in ownership, if there's an applicable exclusion. This is an example. Even though the property has changed hands, it is not considered a change in ownership.
And if you're watching this and you're thinking this is a silly rule, a lot of people think this is a silly rule. So I don't know if it's a loophole or what, but either way, it's a law that exists, and this is the best attack plan we have going forward.
All right, we've got a bunch of questions in the chat, and I also put a bunch of questions we got on email in the slide deck. But now is the time to act. Go to our website, set up a Zoom or phone consult. We're doing Zoom and phone. We're, one of the things that's happened is with, the whole thing that's going on with COVID, we really are trying to minimize the contact with clients because it is highly disruptive to our law firm when somebody's exposed to COVID or might have a potential exposure. It's really, it's just terrible. And a lot of these documents are deeds that have to be notarized and trusts that have to be notarized. So we are really limiting the in-person contact with clients because our firm is extremely busy, like many other estate planning firms, with Prop 19 and also with the change in presidential administration and the potential of estate taxes going up. So you're kind of hitting this convergence. I talk to my colleagues. Conner and I are working literally every day into the evening. Every attorney in the firm is. We're just very busy right now. We do have time for you, but we're very busy. So here's what you need to do. Collect all your recent property tax bills and locate your current estate plan. Please get that to us before your meeting. If you're already a client and we most likely have your estate plan scanned, not so much of an issue, but we do need your most recent property tax bills. So when you get your property tax bill and you pull off the 2 bottom coupons, it's that top one. And the consultation fee is a flat $500. That includes the prep time for us to take a look at your estate plan, take a look at your assets and your family situation and do a quick review of your estate plan and then have a meeting with you. And then at the end of the meeting, you will know whether to take further action or not. Okay. So if it's, yeah, this sounds good, but I need to check with my kids, that's the action you might take. Or, hey, this sounds good, but my kids, I know they're going to sell the property when I'm gone. Then you don't, need to do anything, but you don't know until we go through this. And then if we do additional work, obviously there are more legal fees. So let's get to questions. Ray asks, my home and major investment bank accounts are held in a standard living trust with my wife and 2 children as the ones that will receive everything. Does Prop 19 change anything? Yes, it does. So Ray, set a time we can talk. Joel, CPA from Woodland Hills, asked, does this qualify for continuing education? No. Irene A. from Long Beach asks, I have one single family home in Long Beach. I have in a trust that says when I die, my partner will initially benefit from, and upon her death, the benefits will transfer equally to my nephew and niece. I do not have children. How will Prop 19 affect this situation? Prop 19 benefits you, Irene, and perhaps your partner, if you're either married or a registered domestic partner. Those terms are interchangeable under California law. And so if you are a registered domestic partner or married, when you pass away and that property goes to your partner, there is no reassessment. And so then your partner, if that's still the home, can do all this great Prop 13 stuff. But when it goes to your niece and nephew, it will get reassessed, whether there's Prop 19 or Prop 13, it will get reassessed. Mike S. from Penn Valley. You might want to know where Penn Valley is. It's up in Nevada County. It's a beautiful area. How you doing, Mike? Would Prop 19 only have an impact on property taxes for kids if they decided to live in the property? If they would decide to sell it anyway, the new buyers would be subject to property taxes based on the new assessed value, regardless of what was done before the sale. Correct. There's a lot in there. Prop 19 restricts parent-to-child transfers and makes it harder to inherit Prop 13. Okay. So the answer there is Prop 19 does have an impact, and it's something that, Mike, I know that we have a meeting scheduled toward the end of the month, but this is something that you're going to want to take a real hard look at. Jack C. from Sacramento asks, we bought our home in 2003 and were unable to transfer our Prop 13 tax base because the property cost more than the one we sold. Those are the Prop 13 rules. Did we lose our Prop 13 tax base then? Yes. Our home is worth less than $1 million. Will our home be reappraised when we die and pass it on to our daughter? Yes, you lost Prop 13 because the current rules say that if you buy a home of greater value, I mean, there is a limited exception. You know, there's always these little tiny exceptions, but as a general rule, if you buy a home of greater value, and the rule is it can be 105% if it's a year after you do the transaction, or 110%. But if you sell a house and buy another one in the same year, and it's just a little bit more, you get reassessed on the full value of your Prop 13. Prop 19 fixes that problem. And listen, I know we're kind of beaten up on Prop 19. Prop 19 is a real benefit for a lot of people. And this would allow you, Jack, to, had Prop 19 been in existence, you would have been able to carry your Prop 13 taxes and then add the difference between the sales price of the home you sold and the one you bought. That delta would have been added to your tax bill. So you kind of lost out on that one. Gary asks, is this the one that only affected larger businesses? No, that was Prop 15. It didn't pass. When I die, my home goes to my two daughters. Hopefully the house will be worth more than $1 million and neither daughter has the funds to buy the other out. Does this mean they will likely sell the house and divvy up the proceeds? Yes, they probably will. After Prop 19, an adult child inherits the parent's home, claims the homeowner's exemption, and establishes it as his principal residence within a year. Jason is a lawyer, by the way, and avoids reassessment. Is he essentially stuck living there for life? Conner?
We don't know. Maybe wait for the guidance to come out.
I think probably not, but you can't.
When's guidance going to come out, Jim? What day?
I don't know.
You don't think February 16th?
Oh yeah, that's right. February 16th. That's right. After. Tamara asks, when my mom dies owning a commercial property, does this Prop 19 apply when my mom passes away? Anything I can do to mitigate the effect? Her property is reassessed at death unless she does something before 2/16 of 21. Go to Cunningham Legal and request an appointment. That's a good, Tamara, that's a good example of somebody. You're absolutely somebody who should be paying us a little bit of money to look at your situation and let you know what you should or shouldn't be thinking about, right? What the next steps are. But that's, just a really good question. Yeah, Conner.
Really quick. We talk about these $500 appointments. It might be beneficial, perhaps, to even bring your child to the appointment so that we can analyze all these different issues.
Raymond asks, would a rental property qualify for a GRAT? GRATs are sophisticated estate planning tools. A rental does not qualify for a GRAT. A rental does qualify for a GRAT, but may be inconsistent with preserving Prop 13 after 2/16 of 21. So if your lawyers out there or CPAs and your clients have done GRATs with real estate, you need to pay attention to it. Also, QPERTs, Qualified Personal Residence Trust. The QPERT, at the end of the term of the QPERT, is when the property transfers to the children. If the term of the QPERT ends after 2/16 of 2021, reassessment. QPERTs are for higher net worth people. So they may not care. And here, look, here's the other thing. Our clients who have a lot of high net worth, a lot of times they don't care about Prop 13. Okay. So I'm talking people 20, 30, $40 million and up. Stephanie Esquire from Walnut Creek asks, can the children get the exclusion from reassessment after February 15, even though the death occurred prior to 2016 to February 16th? The answer is, I don't know. Hopefully, but here's an issue. Someone dies February 15th. The kids filed a claim for reassessment exclusion on February 16th. It is possible that the assessor's office would say, oh, there are no more parent-to-child reassessment exclusions. We can't accept that form. So you're probably going to have to work it out on an administrative level with the assessor's office. It's going to require more work. But again, I don't know, because there are two issues. And we've been talking about this a lot in our firm internally, and I've been talking about a lot with other lawyers. There is a change in ownership, and then there's the filing of the claim for reassessment exclusion. Those are two separate legal events. There is the death, which causes the change in ownership. If that happens before 2015, and then you file your claim after 2016, it might be considered a late filed claim. I don't know, okay? And I wish I could tell you, we got a lot of people on here who are looking for guidance. I wish I could tell you, I just don't know. Does that 3-year grace period remain unchanged? Again, I don't know. That's the grace period to file the claim for reassessment exclusion. Rick asks, I have several rental properties. Should I quit claim or transfer them to my children now? I'm 70. I bought my home in 78 for $94,000. It's worth $2 million. Yeah, this is Rick. I would say you're the archetypal person who should be reaching out to us and having a conversation. And it may be, it may be a pick and choose. It may be the kids say, mom and dad, and this actually comes up more than you would think. The dad literally built the apartment building with his hands, okay? And dad's old. And a lot of people have an emotional connection to real estate. And so they say, you know what? I don't care about the other stuff, but when dad's gone, it's like he's still there. So I get it. I understand that's how a lot of people feel. So if that's you, we need to have this conversation, because this is a real conversation. Now's the time to act. Go to our website, set up a Zoom call or phone consult. Again, recent property tax bills, current estate plan, consultation fees $500. At the end of the meeting, you'll know whether to take further action or not. Now, I don't know if we should do these. We have 47 questions.
Let me
Conner, what do you think?
Yeah, we can do some questions. I'm okay if you are, but I do want to say that this week was really busy, and I want to specifically thank the other 5 attorneys, Jeff, Tasha, Janice, Liz, Rochelle, for putting in the time to help us make this, and our staff too, Amber, Nick, Jamie. Our firm's been crazy this past week, and it took all of us really to put this together.
Yeah, and I will tell you, this is something where I've been helping other lawyers, and other lawyers have been helping me to understand this. This is a time to be collegial. This is a time to come together and collectively figure this out, so we do the right thing for our clients. Most lawyers will frankly have too much work to do. This is not a situation where we're trying to sell people on something. We're going to have a conversation with you. And if it's something that we think is appropriate for you, we're going to recommend a course of action. And if it's not, it may be that you do nothing. It may be that you give, in the example of the mom who just lost the dad, and the property stepped up in basis, and she's 92 living in an assisted living facility, it might make sense to transfer the apartment building now, because there is no capital gains tax issue. All right, so we're going to go through these issues, these questions. So stick around. I'm just going to, for as long as it takes, because these are great questions. Does the $1 million exemption apply on a property by property basis, multiple rental properties, or does it apply in aggregate? That $1 million parent-to-child reassessment exclusion that's going away February 15th, it is aggregate. Can you see these questions, Conner?
I can.
All right. You want to do Jason's question?
If an adult child inherits their parent's house and receives the Prop 19 exclusion from reassessment by making it his principal residence in good faith, what happens if he decides to move out? Same, we've hit this one. We don't know. We're going to find out pretty soon here, but good luck.
I would say if I had to venture a guess, it would be you would have to stay there until your name's on the property tax bill. And what hinges the determining factor is whether you claim it as your as the $7,000 homeowner's exemption. So the parent has to claim. This is actually really important. If you ignore that $7,000 homeowner's exemption because you're like $70 a year, it's not even worth filling out. Think twice about that. And that's another thing we'll cover in the meeting. It's a really good idea to put some thought behind which home you claim is your homeowner's exemption, because when the child moves in, the child has to claim that as their homeowner's exemption. My guess is it would be a year, if I had to guess. And is that in the statute, a year, Conner?
I mean, a lot of the IRS ones are 2 years, but keep in mind, your child will self-report if they move and have their property tax sent to a new address, or if they have two properties on file and they're sending it to one address. So we just have to wait and see, but don't get your hopes up.
This is on an example. How do you get 26,000, 5,000 for the first and 25,000 for the next 2 million? Where's the 26,000 come from? I don't know. It could have been a math misfire. Sonata says, I wish this could be repealed. I don't think voters understood all of this, but I think it benefits some people. I mean, Prop 19 benefits people who want to move. So Howard asks, after February 15, 2021, if a child sells an inherited residence before moving in, will the exemption apply, or will there be a supplemental tax bill? My thinking is if the child never claims it on the homeowner's exemption, that there will be a supplemental unsecured tax bill. Do you want to take Preston's question?
Sure. Does the heir need to live in the house for X days for a year to keep the decedent's low tax assessment? Hello, Preston. We answered one, we don't know. Can parents pass a home to a child during a lifetime under Prop 13? And Prop 19 can only allow parents pass to a child after death. I don't know if I understand that one.
So I think what this means, yes, you can transfer your home under Prop 13 now. And after death, Prop 19 limits it to parent to child transfers. So that eliminates all the other transfers. Sally says, use e-recording for deeds. Yes, that's what we do. Dwight Winters, Dwight says, if the house is a gift, to the child, the $1 million exemption still applies.
Yes.
Yeah. If the house.
Aggregate $1 million, I think he's talking about.
It's the residence of any amount plus $1 million assessed value. How does Prop 19 impact commercial property held jointly with a parent and children in an LLC? Cynthia, complicated question. We need to meet with you on that. I can't, we don't have enough facts. Miranda asks, what happens if the property is in a trust and the trust will not be finished, executed, and property is distributed by the executor till after February 16th? Great question. This is something we've been talking about internally. So we handle like many attorneys in our area of law, we help people set up estate plans. We help people through the trust administration process. And this is the issue. Mom and dad passed away. You're working with a lawyer on a trust administration. You really need to think about nailing down that claim for reassessment exclusion between parent and child. But here's a warning. Here's a caveat. If there's more than one child, you need to figure out who's going to get the property. The property may get reassessed if there's not enough cash in the estate. This is a very complex problem. So Miranda, if you do not have a lawyer, contact us. If you already have a lawyer that you're working with, I would go back to that lawyer. Or if you are a lawyer, you understand the issues that I'm talking about. Bill asks, how would this affect an industrial building I own? At death, if your death occurs after February 15th, the property is reassessed. There's no more parent-to-child reassessment exclusion, unless, of course, you bought it with an LLC and it goes to no one gets more than 50% when you die. What about Howard asks, what about capital gains due to the carryover tax basis? We covered that. Remember, a lot of clients, Conner, of ours have capital gains tax issues, and you have to be mindful of that. This is not just a bull in a china shop, doing
yeah, let me take on. We've had a couple clients and even attorneys say, well, what if I just sell the property to my child and I have this low Prop 13 base year value? I sell it to my child and then the child gets a step up. I get cash, he gets Prop 13. Well, there's one important fact. There might be capital gains.
Yep.
If it's a rental property, definitely.
Yep.
Even the main house, though, definitely the case. So you can't forget about capital gains.
Kim says, if the exemption is per person and the parents give the property or a simultaneous death, would there be $1 million or $2 million added to the assessed value, assuming both parents and then child live in the residence? Interesting question. I don't know.
Well, if we
this is post 22. This is post February 15. Kim, this is a really good question. parents own a home. Is this $1 million? Is it on the home or is it a per person exemption? As I read it, it's on the home, but I
Yeah,
don't.
I agree.
All right. Melissa, so to be clear, it looks like it's on the home, not a per person exemption. So, and that's why I make the point. The parent to child reassessment exclusion, it's gone. It's eliminated. So that $1 million or $2 million, if you're married, exemption amount, that is a creature of Prop 13, Prop 58, actually, parent to child reassessment exclusion. And this is a new law. And so my understanding is it's looking at the property more than it is looking at the taxpayer. Melissa says fractional interest transfer pre-2/11/2020, perhaps. That's the half a loaf. We talked about that. Some clients may say, well, what if I give half? Then only half will get reassessed when I pass away.
Which we've talked about as a strategy.
Yeah, and you also may be limited on your $1 million reassessment exclusion. So remember, if you have a property that's assessed at $2 million, that's worth $40 million. If you transfer half of the property, you use up that $1 million exemption. If you transfer the whole property, then, right? Because you can only transfer $1 million exemption, but if the assessed value is 2 million, half the property is going to get reassessed. So again, this is why we need your tax bill, okay? And this is why we need to know the history. Have you given other properties in the past? We need this information to give you adequate legal advice. And this is a very complex problem. It's like on Star Trek, the old one, where they had the 3 levels, the 3D chess. This is very, very complex planning. Barry, hey Barry, how you doing? Asks, can the transfer be to an LLC now and the parent still controls? Perhaps, but you're not going to get the parent to child reassessment exclusion. So that acquisition has to be with the LLC. You want to take Greg's question?
Yeah. What is the impact if the homes are in a trust? I assume you're talking about a revocable trust. It's the exact same if it's in your name as a parent. If you're talking about the Prop 13 trust, then make an appointment and we talk about it.
Sunada asks, my clients own property in an LLC. Sunada, they should speak with us, or if they're represented by a lawyer, go back to their existing lawyer to see if, because basically it's unethical for us to solicit people who are represented, so we're not. So if you're one of our clients, that's fine. If you don't have a lawyer, certainly give us a call. But if you're currently represented, you may want to check in with your lawyer or not. But here's the important thing. If the properties, let's say the parents buy the property and then the parents put the property in an LLC. If the parents transfer LLC shares to the kids, that is considered a change in ownership. Now, it's very difficult for people to get their head around this. There's no parent to child reassessment exclusion. To get the parent to child reassessment exclusion, the property has to come out of the LLC and then be transferred. Okay. And one problem that California has is that might be considered what's called a step transaction. And so you might want to take the properties out of the LLC this year and next year transfer them to your kids. So there are a lot of layers. As I mentioned, this 3D chess layer. Property taxation is more complicated than estate taxation. Okay. It's more complicated than the federal estate tax structure.
So Greg asks, is there an impact of the adjusted basis when a first spouse dies? In California, community property states, it's stepped up. In common law property states, no, it's not. But California, yeah.
But that is one thing that Biden on his platform has said. He was looking at getting rid of the adjusted cost basis at death. Gail asks, if one transfers residence to children prior to death and prior to the February 15 deadline, and the parent resides in the residence, will the home be labeled rental and income from such and be tagged as taxable income? What if the parent wants to sell the home and the child resists? Whose decision will be final? What if I reverse it? What if the child decides to sell and the parents want to keep it? Gail, make an appointment. We have a solution for you where you can not have the children totally in control. We have a solution. I will tell you, Gail, this is an example where we would have a meeting. We would formulate what you want to do. We would write down what you want to do. And once we get confirmation from the Board of Equalization about what the rules are, then we can go ahead and implement the plan. So this will likely be a 2-step. And again, we are a very conservative law firm. When it comes to taxes, we do not take risks for our clients. We want to make sure that it's going to work because, frankly, there's just too much at stake. And another thing too is, depending on the values, if it's your home, you may not need to do it, depending.
This webinar that we're doing, we're really trying to not overpromise, like how it seems like a lot of people are right now. We're hoping things work
Yep.
out. We just feel it's irresponsible to promise all these things without saying any guidance. But we can definitely say, you set up one of these Prop 13 trusts, you don't have to make your kids trustee over that Prop 13 trust. You
Yeah.
don't have to control.
Yeah. Anita asks, hey, Anita, how you doing? If the home is in a trust, and the parents die and it stays in the trust, is it still reassessed? That is considered a change in ownership. Whenever there's a change in ownership, there is a reassessment unless an exclusion applies and somebody makes a claim for that exclusion. So the short answer is yes. It's subject to reassessment, but may not in fact be wholly reassessed. With Prop 19, it may be partially reassessed. But again, Conner, I'm kind of thinking it's going to take a lawyer to figure this stuff out. Honestly, this is getting more. It's getting more complicated for us, not less. Angel asks, if the parents put the house in an intentionally defective grantor trust for a child now, is it qualified for Prop 13? We're not sure. We're still working on that, and it's highly dependent. An intentionally defective grantor trust is not a bad trust. It's defective for income tax purposes, maybe. But one of the wrinkles we have is the powers that the parent retains, and how does that affect Prop 13? So one disadvantage is the assessor's handbook has been pulled off the website. It's a 170-page handbook. I happen to have kept a copy on my computer. So if there are any lawyers out there who need that, I think, we're probably going to be posting that on our website. It is the latest, most current assessor's handbook, but you really do need to look at that when you're considering planning strategies. Enrique asks, what if your properties are not worth over 1.2 million? Well, then it may not be, that was an example. So it depends on the facts. There may be reassessment. There might not be reassessment. We just don't know without talking to you. You want to answer Ashley's question?
How does the requirement to live in the property in order to be granted the exclusion work if you've had multiple children or siblings? Is the exclusion only allotted to one child then? This could trigger a partial exclusion anyways if the other children are not accounted for equally. And that's correct. So I remember when this was on the ballot, people were wondering, how can we pass it to multiple children? And there was no good answer available. So we're just really gonna have to wait and see. There's no guidance.
Carlos asks, is there specific considerations for a living trust? Carlos, absolutely. Especially if you're going to be making gifts. Okay. And frankly, if one child, here's another kind of, I don't know if you want to walk them through this, but if you have two kids and you have a house worth 500,000 and 100,000 in cash, and you want to leave it equally to the kids, and one kid is going to take the house, there will be partial reassessment unless you do something in the trust administration. You actually have to go out and get a loan, a short-term expensive loan to preserve the Prop 13. And we do that quite often. But Carlos, to answer your question, are there specific considerations for a living trust? Absolutely. And that's what the consult's for. Okay. Greg asks, I'm the trustee for my wife's parents' trust. I'm the trustee for my wife's parents' trust. The last parent died in January 2019. Their primary home is in the Palisades, where my wife's two brothers currently live. My wife and I live in their vacation home in Grass Valley. The trust also has a rental in Lake Arrowhead because of issues with the Palisades home. The home has not yet been sold, so the trust is still in effect, and there will probably be no distribution before February 15. Does anything about Prop 19 affect us? Had the three beneficiaries already taken ownership at the death of the last parent? Greg, just looking at your name, I don't know if you're a client already or we're working on your matter. If we're working on your matter, please talk to the lawyer that is handling your matter in our firm. If you're not, absolutely reach out to us. Here's the concern I have is if the properties aren't going to be distributed before February 15th, many times we delay the filing of the claim for reassessment exclusion between parent and child because we're trying to figure out who's going to end up with the property. We might be in the process of getting a loan that we mentioned on the last question so that we can equalize the distributions so that essentially a property is distributed to a beneficiary with debt, okay? But the trust incurs that debt. That's a legitimate way of preserving Prop 13. My concern is, as we're going through this presentation, I'm getting this kind of a not a good feeling viscerally, which is I'm wondering that claim for reassessment exclusion. It would not surprise me if they do not permit those after February 16th. It just wouldn't surprise me. And by the way, it's the Board of Equalization that decides. It is not your local assessor. The term Board of Equalization means that tax policy is equalized throughout the counties. So in smaller counties with small populations, your best friend might be the assessor. You'd be like, hey, best friend. I'm not saying this happens, but hey, best friend, can you cut me some slack on my assessment? Oh, sure. Let me just write this in. The Board of Equalization is designed to stop that from happening. It's also to educate the assessors. Gary says, can I get a copy of the slide deck? Gary, this will be posted on our YouTube page. Do you want to take Anil's question?
Sure. Are there any litigations anticipated on Prop 19 to invalidate it? And how will this affect the planning that is done today? Well, the first part of it, the litigation part of it, when we saw people paying money for this proposition, it was all to pass it. There was almost no money spent not to pass it. So there really aren't groups who want to challenge it that I know of, except for maybe the Board of Equalization, but they're probably just going to go over the minute details. They're not going to want to challenge it in the first place.
Conner, they're just going to reassess everything. That's what I think they're going to do. And then people will push back. And so the litigation probably will come through. It will come in the form of, for example, you submit a claim for reassessment exclusion on February 16th for a death that occurred February 15th. I could see that getting litigated if they say, oh no, and you come up with your argument. Okay. David asks, how is a Prop 13 trust different than a revocable living trust? Mom already has all her rentals in a revocable living trust. A revocable living trust, here's the fundamental difference, David. With a Prop 13 trust, the change in ownership occurs before February 16th. With a revocable trust, the change in ownership occurs when your mom dies. So if your mom dies after February 15th, all those rentals will get reassessed. If you and her set up a time to meet with us by Zoom or by phone, we can go over that with you and let you know what planning strategies are available, if any, because there might not be, but there might be a lot of planning strategies available. I don't know unless we talk to you. But that is the purpose of having the meeting, and it will be a meaningful meeting. It's done not like a sales thing. This is sitting down with you and figuring out what should you be doing to reach your estate planning goals.
When you come away from this meeting, don't tell people that we say you need a Prop 13 trust. That really what we're telling you is we have to assess your situation if you're interested in passing your Prop 13 base your value to your kids.
And we're human, so we want to ascribe a name to things. Humans have named everything known to human beings, right? I mean, that's just what we do. We put a name on it. We put a name on it internally so we know what we're talking about. We know what the issue is. Greg asks, my homes are currently in a trust with children beneficiaries after the spouse. Am I covered? Is this your Prop 13 trust? No. Greg, you need to set up an appointment and come on in. I'm in the middle of updating my trust with you. Is this Prop 13 trust considered a separate trust and created outside of my living trust? Yes. Cheryl asks, will this webinar be available and replayed? A lot of information given. Yes, it will be on our YouTube page. Steve asks, if my property that I will inherit is currently in trust, am I good? I do not plan to live post-death. I do not plan to live post-death of current successor trustee. Steve, I think we need to talk. I need to see what that trust says. It depends on if it's a trust where you inherited. Well, this is another issue for people who have inherited property in a trust. And many people inherit property in a generation skipping trust or some other type of trust. We need to look at those because the assessor's office looks through. Assessors typically ignore trusts. I'll just say in general, they ignore trusts and they look through, okay, what's really going on here? So they essentially disregard most trusts to determine a change in ownership. And so it's very important that we know what that trust says, okay? So I would encourage you to make an appointment. I have 2 kids and my husband has 2 kids. Does each child get a parent-to-child reassessment exclusion? Under Prop 13, each taxpayer, right, each homeowner or each property owner gets $1 million reassessment and exclusion. And again, on Prop 19, we don't know, Conner. Yael, do you want to take this one, Conner?
So if the property is owned by the LLC, parents are the only members of the LLC. At the first death, is there a step up in basis? That is a good question.
No, it's not automatic. If I'm assuming the LLC is taxed as a partnership, on the partnership return, you would make your 754 election and get an adjusted cost basis, typically. Sorry for, we keep getting more. We have still have 32 questions left. We keep getting more. Am I going too fast? I don't know. John asks, LLC property is entirely reassessed if more than 50% of the LLC membership interest is transferred from the original owners. I think I got it from the horse's mouth a couple of evenings ago from the person in charge of entity reassessment. It's if more than 50% transfers to one person. Now, that's different than a person putting a property into an LLC. If I have a property and I capitalize an LLC and I transfer more than 50%, it is reassessed. Okay. So the fork in the road is, did the LLC buy the property ab initio, or was it capitalized with existing property by the person who created the LLC? Hi, will your slides be available by email or online? Great presentation. Thank you. Well, thank you. Yes, they'll be on YouTube. So what can I do now to protect? Enrique asks, so what can I do now to protect my 6 properties? Go to CunninghamLegal.com, make an appointment. We're going to figure out if there's anything you can do or anything you should do. Okay. You want to answer Shane's question?
Have you done e-recording deeds for faster processing? Yes, we do e-recording for most of our clients.
He asks, if I have a client I think may need work, can I pay the consultation fee and discuss their matter with you? Yes. For those of you who have clients who you want to talk on behalf of your clients, absolutely, we can do that. It may lead to more questions that you have to ask your client, and then maybe a follow-up, but that's totally fine. Eric asks, how long does the child need to live in the primary residence to avoid reassessment? We're saying at least 1 year, but it's possible they could say 2. Conner, is that our marching orders?
I think that's fine, but I do think that they're gonna freak out if they see you're changing where your property tax bills are being sent. But I could be wrong. We have to wait and find out. I would say don't get your hopes up, but maybe a year or 2. For the IRS, any of these tests is 2 years.
Eric asks, what happens if a house is left to 2 children equally? How does primary residence work for reassessment purposes? We're joking with each other, saying that they have to live together, but it may not be a joke. I don't know.
Yeah, we'll find out.
Maybe half of it gets reassessed.
My mother is not living in her primary residence, but living with me because of COVID. Does that affect the residency requirement were she to pass away?
I think if she has her homeowner's exemption box checked, you're probably okay. If you rent the property out and you have your homeowner's exemption box checked, that is inconsistent. And you're probably, that's kind of a no-no. But as I read the statute, Conner, and as you read the statute, it looks like it's the homeowner's exemption box has to be checked. That's the real issue. Melissa asks, can the existing rental properties be transferred into a flip or an family limited partnership or LLC with the 51% interest transferred to the heirs to trigger the reassessment and apply for the pre-exclusion? This would retain control and income to the current generation and avoid reassessment because it's only 49. Maybe. That's
transferred existing real estate properties. That goes against what we talked about.
Well, but what they're saying though is by the way, when you make a gift with an entity, if you're out of exclusion, this is more of like your assets are more than 11.58 million. If you have a $50 million estate, we have a client we're doing an estate plan for that where they're using up their $11.58 million exemption. So they're giving 23 million, but they're actually able to give about 30 million in property because you get a discounted valuation when you use a family limited partnership. So those people don't care about Prop 13. So that's, it's kind of, again, this is a balance. Check in with us and we'll find out if there should be another meeting. Kevin, how you doing? Great. Jim, great seminar. Very impressive. What is the authority that transferring the rental to your Prop 13 trust is a change in ownership to the children? It is a change in ownership because it goes from the parent to the child, and the assessor's office looks through the trust, but you have to be mindful of the powers that the parent retains, because sometimes, for example, if the parent retains the right to rents, and that's in the trust, it's not a change in ownership. It's not a full change in ownership, right? So there's these retained retained powers. We have to be very careful. I think there's a workaround. But again, we want to check in with the Board of Equalization and basically there are a whole fleet of people who used to work at the Board of Equalization who are now in private practice. So we're reaching out to those people, and we really want to nail this down so our clients don't step in it.
Let me just Jim really quick.
Yeah.
We can change ownership if we give the kid a fee simple. What we're really trying to do is figure out how much we can keep for the parents without causing a change of ownership back to the parents. And
right.
we have a pretty good idea, but we don't want to overpromise until we exactly know.
Yeah. And again, it's so fact specific. It just, and in law school, they say every case hinges on the facts. And this is absolutely true with this. Christian asks, my wife and I own $8 million of real estate. We have 2 children. Would gifting 50% to each make sense to take advantage of the current federal exclusion and benefit them from Prop 13 tax basis? Christian, it might. It very well might. And I would encourage you to make that appointment with us, and then we can go through those issues and give you a sort of a playbook, a recommended course of action. Denise asks, if I transfer rental property to my child now and file notice for gift tax, child will owe no tax. However, it will trigger capital gains for me. No, donative transfers by gift do not trigger a gain. However, if the property's in a B trust and you remove it from the B trust and give it to your kids, you may be violating the terms of the trust, number one. But secondly, that very well may cause a gain. So again, I would couch this in a probably not, but Denise, that's an example where it would make sense to hire us, look at your situation, and give you a game plan. And by the way, this is literally pennies on the dollars and slivers of pennies on the dollars for good advice.
Denise, so I want to add on, if your kids ever sell that property, they will be paying your capital gains.
That's right, because they get your low basis. Denise asked, does Prop 19 have any impact on step up in basis? No. Greg says, I asked, our rental properties are relatively young, 1031 generated with modest capital gains. Is it not a reasonable strategy to sell all the property at death of the first spouse, resetting the basis and plugging all the money into S&P fund? Yeah, that's what a lot of people do. You know why? Because they're sick and tired of plugged up toilets and leaky faucets. Hello?
You threaten to be sued by your tenant.
Of course, that's what they do. That's a great strategy. Let's see. You want to take Felix's question?
If father and son are living together in home as principal residency, when the father passes, does the Prop 13 taxes get reassessed? Probably not, unless the home has really appreciated since your father bought it.
Mm-hmm. But it might. And again, it's that $1 million, if the value of the property is over $1 million, it becomes an issue. This is not the assessed value, but if the value of the property is over $1 million, that's the red flag, right? So if the property is worth $700,000 with Prop 19, dad's living there, son's living there, dad dies, son continues to stay in the property, and dad leaves the property to the son.
Mm-hmm. Mm-hmm. Just the son.
That's really important, because if dad has 5 kids and he says, I'm going to leave everything equally.
Bridge loan at best.
Yeah, you need a bridge loan.
Which will be hard to get.
It's a problem. Okay. And it's a problem with Prop 19, because if the kids say, well, it's okay if the one kid lives there and the other 4 will stay untitled because all dad had was a house and the one kid took care of dad and we love each other. If those 4 other kids aren't living in the home, I think you got a problem. Jason asks, if an adult child inherits their parents' house and receives the Prop 19 exclusion from reassessment by making it his principal residence in good faith, what happens if he ever decides to move? I think we answered that. We don't really know. Maybe a year or 2. You want to answer Anita's question?
You will also open up inventory, possibly taper prices due to shortage of home. That's a commentary.
Yeah.
I live in a home that is 50% owned by my deceased partner's daughter. Do I have to do anything with this new proposition? I also own a townhouse where my son lives and pays rent. What are the implications when I die and he wants to sell it? This is a tough one. I think this is one where you should do an appointment.
Yeah.
Just because partner, does that mean registered partner, or does that mean somebody who you just lived with?
Yeah. So if you're a registered domestic partner or married, that is a step that may be considered a child, but we need to talk to you about that. And it has to do with your legal status. So again, registered domestic partner, spouse is interchangeable in the state of California. It means the same thing legally. Okay. Joyce asks, my son is renting my vacation home. According to my trust, it goes to him upon my death. Since he's already living in it, How will Prop 19 affect him if he decides to sell it in the future? Joyce, when you die, the vacation home will be reassessed if you die after February 16th. I would highly recommend you make an appointment with us and, go on the email, make an appointment, meet by Zoom, meet live, because that is a real issue. And that property will get reassessed.
I want to tack on, we didn't really say this in our webinar, but the houses that might make the most sense to deed to your kids now, whether it be through trust or not, are vacation homes, because you're not depreciating, and vacation homes that you expect your kids to keep.
And the other thing too is, if you think about this valuable property right, you can sell your home and carry your Prop 13 tax base. Well, there might be some planning opportunities there, right? So you may not want to gift your home. I mean, you might want to gift your home, but there might be some reasons why you wouldn't want to do that, because once it's gifted, then you can't do this Prop 19 transfer of your tax base. If your house is worth under $1 million, do we still have issues with Prop 19? Maybe, maybe not. Prop 19 is indexed to inflation, but remember, it's indexed to inflation. It is not indexed to property values. So if your property continues to go up at 4 or 5 or 6% a year, and your property tax, your property taxes aren't going up by as much, you could be kind of caught. We call it in aviation a coffin corner, which is you can only go to a certain altitude and a certain angle of attack, and then your plane stops flying. What I mean by that is you may find that your property is reassessed because the value of your property is going up faster than your tax base. Okay, and that's kind of a coffin corner. So Sunata asks, so where the grantor is still alive and recently deeded property to a trust, we're the only beneficiary of the primary residence as her daughter who intends to move in and treat it as her primary residence. Is it best to do the gift transfer now or take it out of the trust to preserve Prop 13? I think that's an analysis we go through. And frankly, this may be an analysis, Conner, where we start looking at the market value and the assessed value and let our clients know, once the market value is $1 million greater than the assessed value, there's an issue there, but I'm not sure there's much we can do about it once Prop 19 happens. So again, it's a reason that we want to come in, have you guys come in and talk to you. Ken asks, the parent's property is titled in a living trust. Dad died, mom's in a care facility. I'm legally certified trustee and legal power of attorney. Does Prop 19 affect me? Yeah, Ken, unless you're going to move into the home after they die,
Reassessed.
It's going to get reassessed. And on that one, depending on mom's capacity, they may want to, actually what's interesting on that is it's maybe a sale would work. And this is why there's all these different planning strategies, and you might be able to do a sale now to preserve Prop 13. So that's an interesting one. Amy, who's a lawyer, asks, can a transfer to an intentionally defective trust allow rent income to the parent and still get a step up in basis on the grantor's death? Yes. All right. So can you do a trust that allows the grantor, the parent who puts the property in, to keep the rental income and still get a step up in basis? Yes, but that may be inconsistent with Prop 13. And that's the issue that we're trying to work around. And typically it is inconsistent with Prop 13. It typically hasn't been a problem in the past because you have this parent to child reassessment exclusion on the home. So it's really not been an issue in our practice, but after February 16th, it's going to be a big issue. Mom is older and in an assisted living facility. Can you meet with just the sons to discuss the options? Yes. I realize everything you have to work on is with mom. Yes, we can have that meeting with you guys. And frankly, if your mom's in assisted living, my father-in-law is in assisted living. I kid you not, like a block and a half from our house. We walk the paper over there every morning and give it to him. My father-in-law is a retired vet. Our next door neighbor's U.S. military academy grad. So he gives us the Sacramento Bee and we take it to my father-in-law. I've seen him twice in 6 months since COVID broke, and he lives a block and a half because I can't go in there. If your mom's in assisted living, she probably can't come to a meeting. She probably can't do Zoom. So absolutely we'll meet with you. Typically we like to meet with the parent as well. But if that's the situation, we get it. You want to take Shelley's question?
Yeah. So can one child use a hard money loan to accomplish a non-pro rata distribution to claim his personal residence post-death and qualify under the new law? The answer is yes. Also, what are some examples of capital gains minimization strategies if the property is sold post-death? Post-death, after the gift, I mean, 1031 is the one that comes into mind. Some of our clients do the DST. There might be more beyond that, but make an appointment.
Yeah, or a trust protector can grant a general power of appointment. But again, we don't know if and for lawyers out there, in granting the general power of appointment, in looking at the source material from the Board of Equalization, it says the exercise of a general power of appointment is a change in ownership. And at my reading, and reasonable minds can differ on this, but we need clarification from the BOE, does the granting of a general power of appointment, does that in and of itself cause reassessment? So that's an open question. Kyle, how you doing? He's an attorney up here in Northern California. If a parent transfers their residence to their child and continues to live there, will the parent have to pay rent to the child? Probably. Otherwise it's a gift, right? Ernest says, property with redevelopment transferred lower tax base, is it affected with Prop 19? Is redevelopment transfer able to be continued? Let me be very clear. Prop 19 says that the parent-to-child reassessment exclusion, when there's a change in ownership, is eliminated except for the family home. So I would say it doesn't matter if it's redevelopment. It doesn't matter if it's a disabled vet, whatever the property, whatever your lower property taxes are for whatever statutory exclusion, once that property transfers, then now I would have to look at this, but once that property transfers, it's looking like it would be reassessed. But again, that's something I think we should probably have a discussion. Ernest,
we're on fire. Do you still want to finish all these questions, or do you think we
got 15?
Yeah.
Hey, we still got a lot of people here.
Yeah.
Amy says, must the parent-child claim form be filed and the deed recorded, or will the claim form be enough? Oh man, good question. I don't know. Conner, can you file a claim for reassessment exclusion without the deed being recorded? I don't know. Shelley asks, what are some examples of capital gains minimization strategies if the property is gifted to the children? You can give it to a trust, and the grantor, if the grantor retains a general power of appointment, it is includable in the grantor's gross estate, thereby giving you an adjusted cost basis. That's one thing we're looking at. Another one would be 1031 exchanges or other installment sales or other type of transactions. Ryan asks, how do you plan to provide for a step-up in basis for assets transferred to the Prop 13 trust? Will you rely on reservation of special power of appointment, or will you be using a trust protector to add general power of appointment after the recording of the deed? Ryan, we're looking at adding general power of appointment. We still need to get confirmation from the Board of Equalization to see if that's permissible. Lalit asks, why not give the grantor a general power of appointment? You can. The problem is a lot of times, we like to have the trust protector grant either just a bare general power of appointment or some type of formula where it says we grant a general power of appointment to the extent that the available exclusion amount for federal estate tax purposes. What complicates this is there are state inheritance taxes as well. So if you're living in Washington, Washington has a rather onerous death tax. It starts a little bit over $2 million. It's up to 20%. So that's, you have to be mindful of where the people are living, what the assets are. And again, that's why we have the clients make an appointment with us. Do you want to take this one, Conner?
Yeah. If you do not own a business, can you set up an LLC to purchase a home? Yeah, we do it all the time.
Well, hold on, a home? No. So here's the deal. An LLC to purchase a home, if you do that, you have to pay rent. Okay. That's something to be mindful of, because an LLC is a business entity. You can't put your residence in there.
Well, to get that proper protection, that is correct. But you can put a home inside an LLC, but if you get sued, they're going to be able to pierce the veil. But
not a residence. So that's what I'm getting at. Now, Gavin Newsom, our governor, his home is owned by an LLC, but he's a governor.
People do it because they don't want their name to pop up on a title.
Right.
That's the main reason.
All right. Roughly, when do you expect the BOE to release their final rules for assessors? I would think that they're going to have to release it before February 16th, because they're going to have to start reassessing on February 16th. So I would think, we're kind of comically in jest saying after, but I think they're going to have to get on it. Grace says one of the problems with this new law is that we will probably won't have clarity on the step up in basis either being retained or not under Biden before 2/16/21. Depends on how those Senate elections go in Georgia, I guess. Can the children decide how to split the assets? One takes the money and the other takes the house, so long as the split is equal. John, that's a good question. That is if the trust permits a non-pro rata distribution. So the statutory default is no. Statutory default is a pro rata distribution. So the trust has to authorize a non-pro rata distribution. So when people say, oh, there's all these boilerplate terms in my living trust, lawyers call those boilerplate terms, but they're actually really important terms. Non-pro rata distribution is a boilerplate term. So when clients say, why is this trust 70 pages long or 100 pages long? Can it be 10 pages long? Well, the answer is it can, but you're not going to have all this good stuff in here, right? You're not going to have all these goodies that can help you out down the road. Do you want to take this one?
A rental property is currently in our living trust. Upon our deaths, it would be transferred to a special needs trust. Does that trigger a reassessment?
Yes.
You think even
change in ownership?
What if the special needs child lives in the home?
Then it would fall under an applicable exclusion, but under Prop 19, it gets reassessed. So if you got an apartment building, reassessed. If you have a house, it's reassessed unless the child lives in the home. And has the BOE announced when they release guidance? No. Thank you. Janice says pre-February 16, parents put non-home properties into dynasty with GST exemption trust for children for their life, then to issue remaining in trust to limit the rule against perpetuities. Will Prop 58 transfer currently? When the children die, will it be reassessed when the issue become current beneficiaries of the trust? I went through that kind of fast, but Janice, yes, you will get if you do it before February 16th, you file your claim for reassessment exclusion between parent and child. It's a completed gift. The basis carries over to the donee. When the kids die and the grandparents and the grandkids inherit, it's going to be reassessed. You want to take the last one?
A power of appointment in general, so long as it can be exercised in favor of the donee. This is probably a continuation of what we just read, right? His or her estate or her creditors or the creditors of his or her estate. A grant of the general power of appointment is equivalent to the grant of absolute ownership. A power of a general appointment is not. General is special and includes a power of appointment that is limited by an ascertainable standard relating to a person's health, education, maintenance. Okay, we got a new one. What if the child lives in the house, purchased and owned with the parent as a joint tenant? Well, prior to February 16th, then there's no reassessment. But when the parent dies, the child still has to live in the house, and they're going to take their parent's basis on one half of the house at least.
There's an exception. Danielle, I'm assuming that the parent bought the house and then added the child. If the parent and the child bought the house together, right? So let's say the parent and the child bought it together. This is not where the parent adds the child on as a joint tenant. They are what are called original grantees. So there's no reassessment because there's no change in ownership because they're original. That's the original grantee exception. So it's a very important. And again, I think you can see every situation's different. There are a lot of exceptions, and this is very important that your advisors, your practitioners, your lawyers, they slow down. They look at everything, have a very intelligent conversation with you, a very productive conversation, and figure out, is this stuff, should you be doing anything or not? Okay, so that is the parent and house bought the child together and only the child lives in the house. I think under the original grantee, Conner, under that original grantee. But again, this is information. It's not legal advice. So don't go to the bank on that. And also depends if you've put, if you put half that joint tenancy into a living trust, that can cause a problem. All right.
So I'm going to say though, like one of the themes of what we do today, and this has never really been a theme in estate planning, is February 16th, whatever decision you've made is permanent. So definitely it's worth investigating what to do. What is your best option? That's why these important appointments are so important to make before February 16th.
All right, guys, that's it. We're at the end. Go to our website, go ahead and log on, set up a time to meet, and we'll be talking to you guys soon.
Have a great day.